and other citizens from Midway Estate. Some have left. We thank y'all for being patient. Yes, sir. Come forward. Mr. President, these are citizens who have made a commitment to Hinds County. They love Hinds County. And they purchased property, homes in Hinds County. And before my time, but it was still our responsibility to try to make them whole. I think some other supervisors discussed different estates that was built and things not being done properly, and now the citizens as a whole are suffering. But we'll hear from Mr. Coleman, and he'll introduce the other his neighbors as they address the board.
Good morning to all.
Good morning.
As Supervisor Stokes noted, my name is Chris Coleman. I'm here this morning on behalf of the Midway Estates Homeowners Association. I'll take this opportunity now to let the other members of our association introduce themselves to the board.
My name is Ruby Parks, and I've been in Midway Estate for 16 years. I'm the third house to build in that subdivision.
My name is Harry Horton. Good morning, everybody. My name is Harry Horton. I live in Midway Estates. I've been there for 11 years.
My name is Lester Wall. I'm the Director of Fellowship Christian Athletes in the inner city here, and I've been in this property for right about 5 years.
We're here this morning to address some road conditions and safety issues within our subdivision. I won't go into specific detail about it for sake of time, but I would like to point out an assessment that was done by Durham School Services. Now, Durham provides the transportation services for the Hinds County School District. And they did an assessment, and they noted 3 areas of danger within our subdivision. One of those areas is a culvert that connects a creek bed. That culvert is sinking, and our fear is that it's going to fail while a vehicle or perhaps even a school bus is crossing it. Now, we've requested over the years for the Public Works Department to make the necessary repairs to our roads, but we've been advised that they cannot do so because the roads have not been accepted as county roads. It's our understanding that there were some issues maybe with developers and bringing the roads up to specifications and standards set forth in the subdivision ordinance. However, what we're asking this board to do is take some action on behalf of their citizens to go ahead and get these roads repaired and brought up to standard.
Okay. Mr. Fisher, and then we'll go to Mr. Carl Friedrichs, our road director. Mr. Fisher, would you let know?
Let's go ahead and let Mr. Friedrichs go first.
Okay. Go ahead.
Currently, these roads have not been accepted for maintenance due to the failure of the developer to bring the roads up to specifications. And this is one of the subdivisions that the board is aware of, and we have written up developer letters.
This is the issue that the board was dealing with in our the last board was dealing with. There are a number of these in the county. For whatever reason, starting in the 1990s, there was a failure to properly extend the bonds of the developers or inspect the work. So we have a number of these subdivisions where the asphalt has not had the top layer put on it. You've got about an inch and a half there of the curb line that shows, and the contractor never put the top layer on it. So we took one of them to court, and we are waiting now, and I don't have the status on that. I need to check on that. But we're waiting now to see, by court order, that they are to pave that subdivision road. And if that works, then we have an avenue to take the others to. If that doesn't work, then we're going to have to rethink what we can do. The issue, as far as Public Works is concerned, and the board is concerned, is that this actually still belongs to the developer. For us to come in and do the work is a violation of the law because we're doing work on private property. And we can't do that. The penalty for that is the supervisors, or those who voted to do it, would then divide the cost of that project up between themselves and pay for it out of their own pockets. So we're very cautious on that and looking into it, making sure we're doing the right thing. We are trying to address the issue through the legal means. It's taking a lot longer than I would like, and obviously a lot longer than you would like. And we are attempting to address this through the legal means. So, all I can do is apologize to you for the way it is, and just let you know that we are working towards getting this resolved, and that you aren't alone in this, and that we're trying to figure the best way to go about doing this that can still answer your needs and also protect the county.
If I understood you correctly, you guys are pursuing litigation against some of these developers. It's my understanding that no action has been taken with respect to our neighborhood. And y'all can correct me if I'm wrong about that, but I don't think it has been. And we've been dealing with this situation for years, and our roads are continuing to deteriorate. And with the danger zones, as noted by Durham, I think that our subdivision may be an exception, but we need to do something for the traveling public to ensure their safety.
Let me just say that this particular time, ask Mr. Felix, has an assessment been made? Has anyone visited that particular subdivision? And I will say this to the gentleman and the lady, is that we're very familiar with this problem. It's something that the Supervisor Fisher stated that we've been dealing with. Some of the individuals have actually gone out of business. Some of them have been bankrupt. Some of them actually stated that, and we know for a fact that they simply don't have the money. I don't know the number of subdivisions, but we have one and several that are probably just as bad and worse than yours. Not to say that yours is not worse than any others. But it is a problem that the county and all of the supervisors are aware of, something that we're working toward, something that we will ask the city legal or board attorney to check and make sure where we are as it relates to this particular issue. But it's one that's disturbing to all of the supervisors, and we have taken action on it. Mr. Felix, can you tell us how many we actually are dealing with?
Approximately 28 subdivisions and developers.
28 subdivision developers that have the same problem. And one of the things that I'm hoping that the board will do is allow us authority for you to be in communications with Mr. Felix to just find out exactly where yours is on this particular list. And we do know that it is a problem. And from that, you can respond, then we'll go to Supervisor Calhoun.
Let me just say this. As you guys are well aware, litigation takes time.
Right.
And my question is whether or not there's a mechanism where we can go ahead and make these repairs, and then however you want to deal with these developers, or however you want to pursue that, do that later, but give us some relief in the interim. That's what we're asking the board to do.
I don't think so. I'll refer to the legal advisor, and then she can tell us where we go from that particular point as it relates to you taking your own personal action.
Well, I will say this. As I understand this, the way this works is that the developers come to the board and say, hey, look, we want to make a subdivision. They tell you we're going to make it according to the specifications and the plan set forth in the ordinance.
Right.
They put up a bond, and it's supposed to be ensured that the work is done before the bond follows.
That particular point, what you get to right there, that's been the problem in the past is, correct me if I'm wrong, Mr. Felix, that everyone did not, or the bond expired.
Correct. The bond expired in 2002, but since I've been here, since 2008, we have installed a mechanism to address bonds and make sure they have not expired.
Here's where the rubber meets the road. We didn't drop the ball. I mean, we had nothing to do with that.
Right.
But we're left to suffer. So why, litigation is expensive also. Why should the taxpayers be placed with the burden of pursuing these developers when it was not proper?
Understandable. Mrs. Calhoun?
If you will.
Yes.
Now, if you want us to pursue litigation, I would request that the county fund it on our behalf.
Okay. Mrs. Calhoun?
I was going to ask the public works director if we are pursuing all 28 subdivisions and for payment of those roads to
The
them.
board attorney would have to address that.
My understanding, first of all, let me say, I don't know if I can get afternoon, Mr. Coleman, and you and I have spoken a number of times regarding this issue. And do regret that we're still here dealing with it. And I just want to say good morning to, or afternoon to the other residents there too. Mr. Felix, the entire Public Works Department, in addition to Mr. Smith when he was here, and especially Supervisor Fisher, have worked extremely hard on gathering all of the names of the subdivisions, identifying the developers that left the subdivisions unfinished. We do have a big problem, and it extends far beyond Midway Estates. As far as the legal aspect is concerned, we have done a few have actually proceeded in litigation, on a few of the 28 cases. The one that we started with was the worst subdivision, and that is Crossbridge. All of the Chancery Court judges in Hinds County recused themselves from working on the case. A special judge had to be appointed by the Mississippi Supreme Court. With that, attorney schedules had to be worked out, and we finally have some resolution with regard to that one case, and it was a settlement agreement by which the developer in that case will be given a period of time within which to bring the subdivisions up to par. And the plan is to address the other 28 bit by bit, because these are cases, unfortunately, that do not come up every day. Now, before Supervisor Smith left office, my understanding was that there was going to be a school bus turnaround looked at with regard to Midway Estates, and so that litigation would not be necessary for that subdivision. And so from there, I didn't know what happened. And so it was not on the top of the list, even from a litigation standpoint, with regard to the total list of subdivisions.
Mrs. Calhoun?
My question is this, and I don't know if this is the correct legal term about it. Can we adjourn or combine all of the subdivisions that will fall into this category and pursue taking legal action from that perspective, instead of doing it on a one-by-one case basis? We combine all of those subdivisions and move forward in pursuing legal action.
That is possible, but it probably will prolong the action. As has been stated before, many of these companies are out of business, have become bankrupt, and some of the principles you can't even find. And so that would actually prolong the litigation rather than shorten it.
I guess it's going to be, we're going to have to do
Mr. President, we'll try to.
But can you look at the possibility of combining all of these
I mean, of course we can, but I don't know how else to say it will not work in the best interest of the litigation to include, the more people you include, the longer period of time it actually takes.
We'll meet with the people in the subdivision this week. We'll try to come back at the next board meeting with a suggestion.
Okay. All right. Thank you. Does anyone else would like to just say something briefly?
I would just, excuse me, once again, good morning. Just briefly, and I'll put it down in layman terms. My name is Harry Horton, and I served in the military 21 and a half years. And one of the things I learned as I served is how to do preventive maintenance in order to avoid something that's going to cost us on down the road. And if I just would offer a suggestion, I think this is one of those times, especially dealing with Midway Road because I'm there, is that this is one that I think that we need to step out and do some preventive maintenance, because I truly believe, I'm not trying to predict the future, but I truly believe that we're headed for something that's going to cost a lot of money from an individual standpoint. And then, God forbid, if a school bus crossed this creek and that road decide at that moment to sink, and that is a creek, and then we're looking at children, we're looking at immediate danger and immediate cost that somebody is going to have to pay. And if I would just solicit your help, if there's a way around this, I'm not a politician and I don't know, but I truly believe that there is a way around this.
We find ways around any and everything that we have to do. And I think this is important enough for us to look for a way around it to give us some type of relief until we do decide to get through the litigations or whatever.
Okay. I don't think that you'll find anyone here that's going to disagree with your statement. It's just a way that we have to get to it to make sure that we do it legally. But nobody's going to disagree with your statement. Mrs. Calhoun, and then we'll move on.
I don't know if this is, I would like to see us seek legislation that would give the boards of supervisors the authority to make certain repairs to provide the safety of traveling on roads, and that's in the interim. And if we take a developer to court and we win, that we be reimbursed for the funds that we have expended. I don't know if something legal would prevent us from doing so. But I think we should look at it, because I do empathize with the citizens. They're concerned about not only the repair of the road, but the safety of the road. And somebody has to be responsible for the safety of those roads.
Okay. Thank you very much. The other gentleman, we'll just allow you briefly to just state something, and we'll move from there.
Again, just agreeing with the homeowners there. I'm one of the younger ones for coming into the area there. But again, I've noticed within the last month, actually within last year here, my tax is going way up, and I'm sitting with a great big section here. So how can my property go up when I got these bad places there? And so we're paying pretty good from the homeowners for there, our insurance and our property tax. And it's going up. Why is it going up when we got that? So but we just thank y'all for what you're going to do on this project, please. And we understand that, but we appreciate the efforts.
Thank you very much. We appreciate you. And as I stated before, nobody's in disagreement with anything that you said. And we'll ask the board attorney to put that on our list to make sure that we either seek to sue them all at one time if it's in the best interest of the county and the citizens, or we come up with a strategy as well as Mr. Stokes has decided to where we can at least show them or actually work on this situation. But I will assure you that you're not alone. Okay. Thank you very much.
Thank you, Mr. President. Mr. President, I want to move to item 6, and I got the tax assessor in the audience, collecting machinery. And Mr. Stokes, collecting machinery, while he's coming forward, it's a major loss for Hinds County. The city of Jackson has sales tax, and they'll be able to, recoup some of their funds that's lost. But for Hinds County, when we look at ad valorem taxes, we're gonna lose the most, and we don't have sales tax. And that's the issue I was talking with our economic development director about. You got to get more involved with the city of Jackson on these businesses, because it hurt us harder than it's going to hurt the city. Mr. Stokes, thank you for being here. Can you kind of give us the numbers with collecting machinery? And they're leaving off Highway 80. They're building a new location in Rankin County. Could you give us the numbers that you have, please?
As of right now, the real property is assessed. Now, these are just the businesses that's planning on leaving, because they do have some that's across the street that the information we have, they were stated in play. But as of right now, real property is valued at $2,688,660. Now, that is the true value. Your personal property is $6,538,940. That is true value. If you look at the assessed value on real property that you're actually paying your taxes on, is assessed at $403,299. The numbers you're looking at in personal property is $980,842. With the combine of both, they're looking at what they have out there to assess is $9,227,600. The assessed value of that, what your taxes are paid on, is $1,384,140. If you keep your current mill rate plus the city of Jackson at the 171.35, your tax dollars is $237,172. That's what you're receiving now. As long as that stays in place. Now, if they're there as of January 1 of 2013, they still will be assessed. The assessment of the building itself, the real property. But the key is, will they still have all of the personal property there, or will they move some of it out? So you are going to look at some difference in values there. And down the road, when we normally reduce or do things to structures that's empty, you're looking at, right now with the assessed value, just on the real estate side, is what you're collecting in tax dollars is $69,105. On personal property, with the tax dollars you're looking at is $168,067. So once they come out of that building or the facility that you're looking at over there, you would only, with depreciation, the county for its tax dollars and the city from that building or the real part would just be $51,829.
A major hit.
Yes, sir. You're losing over $185,343, and the bulk of that is going to be your personal property.
In our school system,
Ma'am?
our schools.
Well, the schools also lose. But what I did, I just used the whole total mill rate. The schools plus the city of Jackson plus the county millage. And their millage is 171.35. That includes all of that.
Thank you, Mr. Stowe. Mr.
Thank you,
President,
Mr.
I flagged this item on the agenda because a few weeks ago we had the economic development gentleman in here, and he said they did everything they could, and most people saying the only issue that forced plugging machinery out of here was a driveway. And somewhere down the line, because the county and the schools, we're losing a tremendous amount of tax money. We have got to start being involved in these discussions with the city and the business people. We just can't allow the city to close the doors on some of these businesses that's going to really hurt us harder than it's going to hurt the city. And it's going to hurt the schools harder than it's going to hurt the city. So, you know, it's too late now probably to put the genie back in the bottle in terms of plucking. But we need to be mindful of all other businesses in this county. And we got to get our economic development people involved a little more with negotiations. So thank you, sir.
Okay, I just want to add to that, Mr. Stokes, that I totally agree with you. And we will probably have the economic development director to do some more research on this, because I was told that it was because of that driveway that you stated, and that Rankin County gave them the property that they were building on. I don't know if that's true. But I will at least ask him to do some more research on it, and we'll go from that particular point.
Thank you.
Okay.
Mr. President, on number 3, I'm trying to get discussion in. I'm sorry.
I wanted everyone to be certain that we make certain that Hines County did not play a role in Puckett leaving the city of Jackson. We did not play a role in that departure.
Mr. President, I had someone comment to speak. I'll hold the other item, but then go to Ms. Davis. We'll come back to him.
Okay.
Thank you.
All right. Thank you very much. Mrs. Davis?
Okay, thank you, Mr. President. The first item under County Administrators and Planning Bodies, there are none for your consideration today.
Okay.
Next item is request approval and acceptance of property deed for property located at 906 Maple Street across from Lanier High School from the state of Mississippi.
Okay. What's the pleasure of the board?
Move for acceptance.
It's been moved. Is there a second?
Second.
It's It's been moved and properly second. All those in favor of?
Aye.
Opposed to? Motion passes. Okay?
Okay. Mr. President, I would like to remove items C and D from the agenda.
Okay. Before you proceed, for the record, Rhoda, would you please read the order?
Yes, and this is actually a combination motion of the board attorney's item and Ms. Davis's. Resolve to approve.
No, those are separate
Those
issues.
are separate?
Separate issues.
Okay. All right then. Resolve to approve and accept the property deed for property located at 906 Maple Street from the state of Mississippi.
Okay. Thank you very much. Mrs. Davis, continue.
Okay, next item would be personnel. There are no items from Mrs. Parker. However, I believe Mr. Stallworth, on behalf of the youth court, is here to submit the revised personnel policy.
Good morning, Supervisor.
Morning.
This is being submitted as a minute insertion from Judge Skinner as it relates to his policy and procedures. Please be advised that the youth court policy and procedures as personal issues. It is my policy as appointed the youth court judge at Henry Young Juvenile Justice Center that all employees work at the will and pleasure of the judge and can be terminated for any cause at any time. It is also my policy to promote, transfer, suspend, demote, and appoint any employee at any time, as well as increase or decrease in salary at any time. Signed by the Honorable Judge William L. Skinner II.
Okay. Before we go to a motion on this, I'd like to hear from the board attorney regarding this particular issue.
Yes, Mr. President and board members, each elected official is responsible for putting on the board's minutes or placing on the board's minutes their personnel policies or procedures. Any vote that the board would take would not be to accept the substantive portion of the procedure, but merely to have it as part of the minutes. And this is also supported by state law that the youth court judge, that the employee serve at the will and pleasure of the youth court judge. So it's merely a request to place these policies and procedures in the board's minutes.
So do we need to take a motion? Can it be just a minute insertion?
It can be just a minute insertion, or the board can vote to accept and place it in the board's minutes. But either way, it would need to be in the board's minutes, and it is within the judge's, just like any other elected official's discretion, to determine their personnel policies and procedures.
Okay. Ms. Calvin?
The only concern that I have, I think that the judge needs to specify youth court employees and not the detention center employees, because the detention center employees are that of the board of supervisors under the county administrator. That's the only concern I have.
Okay.
That he needs to specify youth court.
Okay.
Under the authority of the judge.
I think this is kind of vague at this particular point, whether or not that has happened. And I think that we need to, I'm pretty sure the judge will probably, unless you tell me any different, will be able to specify the difference that he's referring only to the people that comes under his purview.
Correct.
Okay. Is that the way you interpret that, Ms. Martin?
Yes, reading the letter as a whole, I think it does clarify youth
court.
Okay. The only thing that I have to, under this particular issue here is I'm just now seeing this, and I'll just leave it at that. Okay. All right. What's the pleasure of the board?
I move for approval of the youth court personnel policy.
Okay. Is there a second? Is there a second?
The only reason I'm not going to second it is because I still think it should be specified that within his authority, because you do have detention center workers there that come under the authority of the board of supervisors via the county administrator. That's my understanding.
Okay.
And I think, and that it said, please be advised that the youth court policy.
Okay.
And again, this would merely be for acceptance in the minutes and not an approval of the overall policy.
So this is only accepting into the minutes amended insertion.
Can we just insert it without voting?
Yes, you can.
Well, I prefer to just insert it.
So in order to do this properly, we need to have an amendment to do it. Does it need to be amended to put this into the as amended insertion, or just stated?
It can really be stated as a minute insertion.
Okay.
No action is taken.
No action required. Okay, so we still need to vote on it. Okay. All right. Thank you. All right. Okay. Thank you very much. Thank you, Mr. Stoller.
Thank you.
All right. We will continue on.
Drop your motion.
Yes. Okay.
The next item on the agenda is from Mr. Darrell McCorder, Director of Permit and Zoning, with one issue for your consideration.